going to go ahead and call to order this meeting of the Park Ridge Municipal Officers Electoral Board. It is Monday, January 9th at 8 a.m. Can we have a roll call?
Yes, I'll be glad to do that. You want me to?
Yeah, please. Thank you.
Okay. Mayor Maloney.
Here.
Attorney Julie Toppendorf.
Yeah, not a member.
Here, definitely. And Alderman Roger Schubert.
Here.
And I am Betty Henneman, City Clerk, also present.
Okay. As we were all here a little bit over a week ago, the hearing was continued till this morning. My understanding is that the records check did occur at Cook County. Julie, is there anything you want to add about that, or anything we need to do before we jump in?
I'll report on that.
Okay. Go ahead.
Little lower.
Oh, okay.
Number 7.
Okay.
Yeah.
Then we'll just keep moving forward in the agenda. The first item on the agenda is the approval of the draft meeting minutes from December 30th, 2016, and I'll entertain a motion to approve those minutes.
So moved.
Second.
Thank you. Any questions or corrections? Anything from the audience? Any questions or corrections on those minutes? Seeing none. All those in favor signify by saying aye.
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 Those opposed? That motion carries unanimously. Then we're going to continue with the call of the docket. This is case 2017-MOEB-01, Mazuka versus DiStefano.
Okay. You can go right to number 6.
Okay, so now we're going to move forward to rulings on preliminary matters if filed.
Yeah. Do we have any preliminary motions to be filed by either party? It.
I need your name. Sure. Mark Mazuka for the objector. I have no preliminary motions to file.
Leonard Canada, Leonard, Cannata, counsel for the candidate. No preliminary motions.
Okay. Thank you. Next item on the agenda is just reporting on the Cook County records exam. Last Friday, the Cook County Clerk's Office conducted a records exam with representative of the County Clerk's Office, the candidate and the objector both in person. Representative from Ansel Glink from my office was present. Cook County Clerk's Office went through the 22 signatures on the candidate's petition that had been objected to. One by one, compared them to the county clerk's voter rolls, and their determination, which was included and provided to the electoral board, and the candidate and the objector both have copies. Their conclusion or their rulings on each one of them are included in the report that was issued by Cook County. In just kind of in summary, the report concluded that 5 of the objections were overruled, so that the objections were not sustained. 17 of the objections were sustained, meaning that the county clerk report determined that they were invalid. Either they were not registered, the signature did not match, or the address. There was some deficiency with the address. So in short, there were 67 signatures required. There were 22 objections filed by the objector, and 17 of those objections were sustained by Cook County. The report is provided and should be entered into evidence as board exhibit. I think it's 11, but let me check. So we make sure that it's official. Yeah, board exhibit 11 into the record. The next issue would be to continue the hearing. We don't need to formally open it back up. It was continued. It was never closed at the last meeting. As everyone recalls, the board adopted rules for procedure at the last meeting, and so those will continue to apply to this proceeding as well. The next issue would be actually holding the hearing on the 2 objections. We would allow, and just to summarize, we would allow the objector to make his case first, it's his burden, and then allow the candidate or representative to respond. The rules allow for rebuttal if desired. It's up to you, objector, whether you want to separate out the two objections, the notary, and then the signatures, or do it all at once. I think that the board is fine with either one, but I think we would turn it over to the objector. Witnesses do need to be sworn, so I don't know if the court reporter could swear in the witnesses as they come up, that would be great.
I have no witnesses. Unless you count me.
Yeah, that you are. You would be if you're testifying. So can you swear him in?
Thank you. So my case has been laid out in my petition. It has two parts. One is an objection to the petition sheets that were included in the nomination papers. The other is the objection to the statement of candidacy. Taking first the petition sheet objections, as you already heard from the city attorney, a records check has been conducted by the county in which 17 of the 22 items that I had objected to were sustained. If indeed any one of the 22 that I had objected to was sustained, that would render the number of valid signatures required to be on the ballot below the minimum 67 that are necessary for this office. So just going through the nominating petition sheets and what was sustained and what was not. As you can see, I think the State of Illinois Candidates Guide is amended on November 22nd, 2016, has already been entered into the record as an exhibit. Is that correct, Mr. Chairman?
It doesn't need. You mean the statute itself?
The Candidates Guide.
I don't think we have it. Do you want to have it entered? We'd need a copy of it.
Okay. Well, I don't have a copy handy, but it is available. Anyway, I'll just reference.
That's fine.
If that's all right.
Mm-hmm.
In the Candidates Guide, it explains the requirements for nominating petition sheets, and then it references the proper sections of the ILCS. So in the petition sheets, you are the Candidates Guide states that petition signers must be registered voters in the political subdivision in which the candidate is seeking nomination or election. The citation in ILCS is 10 ILCS 5/7-10, 8-8, 10-2, 10-3, and 10-4. There were 4 sustained objections related to a signer not registered at the address shown. Page 2, line 1, 2, and 4, and page 3, line 11. Further, in the Candidates Guide, it states that a signer must sign his or her own signature on the petition. The signer cannot sign for someone else, such as another member of his or her family. The citation is 10 ILCS 5/7-10 and 10-4. There were 12 sustained objections of falling under that heading. 11 of them were that the signature was printed. It was actually not a signature. It was simply a printed name. And then the final one, if you look, I think it's my exhibit B, I believe, but it's the nominating petitions of the candidate. You will look on page 5 of the nominating petitions, line 6. You will see that the address that was immediately above the address in line 6 on line 5 appears to be identical. So it looks as if the person who printed their name on line 5 also attempted to sign the name on line 6. So that's where I started to look at and think, well, something might not be right. Again, the county sustained that as well. So there were 11 of those that were sustained because names were printed, signatures were not provided, and the final one where something that seemed to look like a signature did not at all match what was on file for that person. The final item on the nominating petition side, the candidate's guide states that petition signers shall indicate on such petition their residence, address, written or printed, including the street address or rural route number, as well as their city, village, or town, county, and state. However, the state, county, city, village, and town of residence may be pre-printed on the petition form when all of the electors signing the petition form reside therein. Standard abbreviations may be used in writing the residence address. And the important thing to note here, a petition signer must be a registered voter from the address shown opposite his or her signature on the petition. That citation is 10 ILCS 5/7-10, 3 and 3-1.2, 8-8, and 10-4. In that case, one of the objections I raised was sustained. This was on page 2, line 13. Of the ones that were overruled, I'd like to just go back and mention a couple things about those from the hearing, from the discussion we had with the county. On page 1, line 15, the name Cirillo is actually, the signature for Ms. Cirillo misspells the person's last name. The person with the county viewed that the signature as being close enough, although I would point out that it's not common that people misspell their own last name when signing. Page 4, line 11, the county viewed the first name as being close enough, even though the person did not include their entire signature. And then just as one other one I'd like to talk about today, the issue of the incorrect address that was overruled. Page 3, line 2, you'll note the address is Linolin. There is no Linolin Street in Park Ridge that I am aware of. However, the county said close enough. So even though 17 of 22 objections were sustained, one could make the case that the county was very much giving the benefit of the doubt in their review. Moving on, I'd like to now go to the statement of candidacy objection. A statement of candidacy according to the State of Illinois Candidates Guide. The citation here is 10 ILCS 5/7-10, 8-8, and 10-5. Mentions that each candidate, whether an individual candidate or one whose name appears on a group petition or certificate of nomination, must complete and file a statement of candidacy. Further on, it states the candidate must swear to or affirm and sign the statement of candidacy, and the statement must be notarized. This is really the crux of the second objection, that this document was not properly signed, dated, and notarized. Under the Illinois Notary Public Act, the citation here is 5 ILCS 312/6-103, Section A. A notarial act must be evidenced by a certificate signed and dated by the notary public. Now, you'll note in the nominating papers of the candidate that there is a date on the statement of candidacy, but the date has been scratched out. Now, there is a very standard way of fixing fixing errors in a notary certificate. The American Association of Notaries states, if a notarial certificate requires corrections, the notary marks a line through the incorrect information, initials it, and writes in the correct information at the time of notarization. The corrections must only be made at the time of the performance of the notarial act when the principal signer is present. A notary must never white out any mistakes, errors, or other information in the notarial certificate. You'll note that in the nominating papers, the correction was made by scratching out the sum value, whatever was originally there, but there was no initialing of this change. Similarly, the National Notary Association. So there's no real debate on how you fix these things. Their point on the topic is that too much helpfulness isn't always a good thing. Signers sometimes bring documents to notaries with the notarial certificate information helpfully filled in, but often this information proves to be wrong. The county named in the venue, for example, may be incorrect. Their point is that fortunately such errors are easy to fix. The notary simply lines through any incorrect words, neatly writes in the correct information immediately above, and then initials and dates the correction. So looking at what is normal and customary for a notary to fix an error in the notarization certificate, it appears that in this case that was not done, the normal and customary fix. There was no initialing of the scratched out and replaced value, no dating of that particular point, and therefore, as far as I can tell, that is not a typically notarized document, and I would argue that it is not a validly signed, dated, and notarized statement of candidacy as a result. So those are really the two issues in my case, board members, that the total number of valid signatures falls well short of the 67 required to be on the ballot, and the statement of candidacy was not signed, dated, and notarized properly. Having not met both of those requirements, I believe the facts and the law would support that Mr. DiStefano did not do the minimum that is necessary to be on the ballot by the date required, and therefore the relief that I'm seeking is listed in the petition. Thank you.
Thank you.
Thank you.
Right.
Oh, I'm sorry. May I enter into the record? I did quote some other sources, the National Notary Association and the American Association of Notaries. Would this be helpful?
Yeah, that's fine.
Sure, Mark.
Okay, we'll mark these as Exhibit 12 and 13.
Mr. Canada?
Yeah.
Okay. Mr. Canada, if you'd like to come up.
Hello. Once again, Leonard Canada on behalf of the candidate, Patrick DiStefano. We reject entirely all of the objectors' objections, and we're prepared to compile and tender affidavits to the effect that each of those individuals sign those petition sheets, as well as are either in the process or did register with the county or updated their addresses and did not reflect in the county system. As to the second issue of the notary, I was the notary. I reject the documents that were submitted into evidence by the objector. Those are not binding precedent. If need be, I can provide sworn statement or an affidavit to the effect that I was the one that did make the change to the date on the statement of candidacy. Other than that, we are willing to prepare and compile affidavits to the effect, and I have nothing further.
Thank you.
Well, I guess I would ask, are you prepared? Do you have those affidavits today? We're running in a very short time frame to get.
Right, we're running in a very short time frame. However, all challenges, I believe, need to be completed by within 35 days of the actual electoral date, which does provide us some time to compile those. But it will be up to the ruling. It'll be up to your hearing, but we are prepared to compile them. We do not have those right now, but we are prepared to compile and tender.
Excuse me. I would like to object to that. I believe that the rules of procedure that you have established here with this board require that upon completion of the records check, any objections must be delivered in writing within 24 hours. 24 hours elapsed somewhere after, I believe, 11:35
been adopted, then we will respect those rules. However, in light of the weekend and no business being conducted traditionally on Saturdays and Sundays, I do ask for an extended window. In addition, compiling 17 or 22 of these signatures does take some time and affidavits. People are not home. It's just simply an extension I think would be permitted or allowed in this circumstance.
I'd like to point out that what's typically customary for Cook County under a Rule 8 motion is 24 calendar hours. I believe this board has stuck with that very similar sort of time frame with their rules. So while I understand and appreciate the difficulty of trying to obtain affidavits for so many invalid signatures, that's not typically what is done as far as my understanding in Cook County or based on the rules that you've set forward today. Thank you.
And then based on that, it is also within the power of the electoral body. There is a level of discretion that may be had.
Can I ask a question?
Oh, of course, and I think that this would be a good time for the board to ask any questions.
So if anybody has any questions, feel free. Mr. Kanata, I do have a question for you. I just want to clarify. So as of right now this morning, even Mr. Mizuka's claimed that 24 hours lapsed, but even if we were to extend that to allow for evidence to be presented this morning, you don't have any affidavits or anything to
present this morning, correct, I do not.
Okay.
As of this moment, correct.
All right. So realistically, how long are you, I mean, I know you mentioned 35, just wrote it down.
I believe it was 35 days. You have until 35. All hearings must be closed, I believe, 35 days before the election.
But I think, the important thing is, when does the ballot need to be certified? And it's January 26th, 27th? I can't.
Let's move closer. It's a bit closer than I had predicted.
Do you have that date?
Cheryl, do you know?
Yeah, yeah, let's check that. I had it written down too, and I didn't bring it. I thought it was the 26th or the 27th. If we push this off until then, and I'm telling you and the objector the same thing, that if the hearing is pushed off till then and somebody's not happy with the outcome, you have almost zero chance of getting to the court in time for the ballot to be certified. So, I think we've already, because of the records check, we already had to put this off. We're here. It's 35 days isn't going to be helpful. So I think what the mayor's asking is, what is the absolute shortest time frame, right, that we could get information from you that you would be prepared to present if it is up to this board to decide whether it does continue this.
I guess that's what I'm trying to say, because based on what we have, like, the Cook County ruled one way, and there's nothing you're presenting this morning that objects to anything Cook County ruled on. I know you've verbally objected, but from an evidence perspective, there's nothing you're presenting today.
Correct. There is nothing I'm presenting today. However, I am asking for an extension to present proper evidence and affidavits to the effect that those are valid signatures or they were in the process of being registered and not updated into the county system. We do respect any determination of this hearing body.
Okay. So
27th, okay.
So back to from understanding that maybe that's a more realistic time frame that we have to kind of work within.
Right.
What is there a pared down request that you can make, or are you just going to?
Oh, next Monday we could have it. Affidavits presented. Okay.
I will tell you next Monday, from my perspective, and I'm just speaking on my own behalf. You guys can jump in. Next week I'm traveling for work, so
okay.
I'll just tell you. From the longest, I'd like to see this extended if the majority of the board wants to give some time to get that evidence collected. I think Friday is probably the longest that I can really see.
I would like Friday also.
Roger, I don't know what your week looks like.
I'm not here Wednesday through Friday of this week.
Okay.
So I'm traveling for work.
Well, we need 2 members, so.
And I can be here, I think, Friday and maybe next Monday, but beyond that, I'm not sure.
Okay, so therein lies the challenge that we're facing here. So if we push it to Friday, then there's 2 of us here.
Mhm.
If we push it to Monday,
There's 2.
there's 2.
Yeah.
Mr. Chairman, I'd like to point out that my objections have been filed since the last meeting in December.
Mhm.
I believe that my deficiencies in the objectors' nominating papers were laid out clearly in that petition, and that they've had quite a bit of time to cure any of those deficiencies, in their, at least in their mind, through affidavit over the last several weeks. And continuing this any further, after the county has already ruled on these deficiencies, I don't think that's really fair.
Thank you.
And to that extent, we understand what the objector is saying, and we have had sufficient time, we believe, to do those. But the county did not make a ruling until last Friday. And we are of the wholehearted feeling that these signatures were indeed valid, these were registered voters. Therefore, there would be no need to make those defenses, since he did not prove his case until last Friday.
Well, it's up to your decision. What we might do is talk about the statement of candidacy, because I mean, I know you've offered the
Yes.
And you're here, so we don't need an affidavit from you. You could be sworn in and testify to it. But I think that we could probably get some resolution of the notary issue, and then talk about whether or not you want to continue the signature issue. Does that make some sense?
Sure.
So, okay. So just from a legal analysis and having reviewed the case laws on statements of candidacy and notary deficiencies, it seems pretty clear from a significant number of cases that a technical deficiency in a notary is not sufficient to invalidate the candidate's nominating petitions. And I can cite some of the cases that state this. There are a couple of Cook County board decisions: Hendon v. Davis, Lay v. Williams, Villarreal versus Aguilar, and that third Cook County board decision was almost exactly like this one, where the notary had handwritten a correction of the date by crossing out 1994 and handwriting a 5 above it, so it would be 1995. And the board determined that that did not invalidate a candidate's nominating petitions, factually indistinguishable to this particular case. There are also appellate court decisions: Cortez v. Municipal Officers Electoral Board, Aiken v. Barron, both holding that a minor deviation in the notary block does not invalidate a statement of candidacy. One of those decisions actually had no date at all in the notary block, so it was still determined to allow the candidate to run. And this is under the rule that substantial compliance of certain electoral requirements, so certain election code requirements for candidates, is sufficient. In this case, the notary block on the statement of candidacy is a substantial compliance provision, so that, I mean, obviously it's still up to you to make that ruling, but I think that there is substantial case law that would say that this type of a defect, this crossing out, would not invalidate the entire nominating papers and candidacy. So that is the kind of legal background of this, but I can certainly answer any questions. We also have the person that notarized it here. Normally you would correct it through an affidavit, but we have the person who states that they had done the notary block and stated that it was their own correction. So,
Julie, along those lines, so you mentioned that the case law seems to favor Mr. DiStefano. Are there other cases that wouldn't? Are there other legal precedent
Yeah, I didn't find any cases on crossing out or handwriting a date that would have been a problem. I think a complete failure to notarize is clearly a deficiency. So if the statement of candidacy had not been notarized at all, then there are cases that say that is not sufficient because it is important to have that document notarized and that the person signing it is swearing before the notary public, but nothing similar to this situation.
Okay.
Usually it would be a complete failure, or the notary is not. I think there's one case where the notary was a notary out of state or that had expired. Those sorts of things will call into question.
Okay. Okay. Hold on one sec. Is it appropriate to take questions?
That's up to you, yeah.
That's fine. Yeah, go ahead.
I know that the candidate's counsel is the notary listed on that document. Has he been sworn?
We can certainly do that. Even if he hadn't been here, the case law doesn't require an affidavit to cure. They consider this a technical deviation, but we can certainly, for the record, have the additional evidence. So, can you swear him in? Thank you.
I move for judgment on the ruling regarding the notary.
Do you want? You're sworn under oath. Can you testify? Can you? You had previously stated, not on the record, that you were the notary, and you had corrected that. Can you state that for the record?
Correct. I state the record that I was the notary and I did make the correction on that date. So that scribble was me. So I testified to that extent, and as such, I move for a ruling. I move for a ruling on the notary stamp.
Okay. Do you want to respond to that, since he's moved for the electoral board to rule on the notary? We should give you a chance to respond. That's fine.
Mr. Canada, it appears that the statement of candidacy, the notarization block in the statement of candidacy was actually filled out in the handwriting of Mr. DeStefano. Is it your testimony that you actually signed and dated the notarization block as required under the notary public?
I signed and dated the notarization block.
Thank you.
Okay.
No further questions.
Thank you.
Thank you.
So what that means is that the candidate has moved for judgment on this particular issue, so that's before you for a ruling, if you're prepared to do that, just on this issue, obviously not the petition signatures.
I'd like to make a comment about that, and maybe this is not at the exact appropriate time to say it, but I'm very surprised to see the neglect in this document by a notary who should know, because obviously you've been an attorney and you've had this privilege for some time, and your notary is about to expire almost exactly on the date of the election. So that's kind of strange to me too, that you would make penciled or penned corrections to the stamp itself and not have it fully approved, and certainly would use it indiscriminately in the manner you've done. I think you need to take the whole situation a lot more seriously in your future, because the notary republic...
The date on the notary stamp was not altered.
No, I noticed that wasn't, but nevertheless, you know, I feel that you're just being a little bit careless with the use of your notary stamp, and I wish you would take it more seriously, because that group of people really has its rigid rules, which all of the clerks and all of the communities take very seriously with their own notaries. Please use it more wisely in the future.
Okay. So we've been requested to make a ruling. Given the, how do we do vote? Is it a vote, or do we each sort of state our position? I just want to make sure I'm following the right process here.
Right. Well, there is a motion that's been made, so it's a little different than you making the motion. So it's before you as a judicial body. So you can each make a comment on it and then vote on whether you grant his motion for judgment on this, which means that the motion would be to overrule this objection. So find that the notary was valid. I know it gets a little confusing, but yeah.
And we do that individually, right? There's no roll call, voice vote.
We can just go down the line, and it would be a vote in favor or not in favor of the motion.
Then I'll start, if that's okay with everybody else. Given the evidence that we've heard today, the testimony and the information provided by Julie in terms of legal precedent, I find in favor of the motion that Mr. Kanata has asked. So am I phrasing that correctly?
Yes.
Okay. So I find in favor of Mr. Kanata's motion.
I'll go next. So yes, with the evidence presented, I also agree in favor of the motion that Mr. Kanata has presented.
And in spite of my comments, I also will rule in favor of the motion because that is the direction of our judgment.
Okay. So what that means is that it's 3-0 to grant your motion for judgment on this particular objection. That means that it's overruled the objection on the notary block on the statement of candidacy. That leaves the second part of the objection, which is to the petitions and the signatures. And that objection and the case law on that, and just to kind of summarize this before we decide what to do on continuing, is very different than on the statement of candidacy. The notary block is a substantial compliance election code provision. The petitions and the number of signatures is a mandatory provision of the election code. In other words, the case law is very clear, and particularly a recent Illinois Supreme Court decision, that a candidate must submit the minimum number of signatures. There's no substantial compliance if they're one short. They have to have, in this case, 67 valid signatures of registered voters who are registered at the address that they sign next to, signing in their own name. Those are the requirements to qualify to run for this particular office. And I would ask you, because would ask the candidate and the representative, this is a pretty significant number of signatures that Cook County has ruled that were invalid, and that's using their language, that these are 17 invalid signatures, whether it's they're not registered to vote, whether the signature's not genuine, or the address, there's an issue. I always want to err on the side of giving the candidate, and we all should, giving the candidate an opportunity to present their case and rehabilitate. But I think it's worth asking at this point with 17 signatures that do you believe that you will be able to rehabilitate all 17 signatures? I mean, I know you're asking for a continuance, you want to bring in evidence. If some of these are fatal, in other words, there's no way to rehabilitate them, I hate to have this board and everybody here have to come back and meet again if there isn't the ability to rehabilitate all 17 signatures.
Can I confer with my client briefly for about
Yes.
30 seconds?
Great. Okay. We take just a couple-minute recess?
Do I have to do it?
No.
All right, we're just going to take a couple-minute recess. Yep.
I think we've been more than accommodating.
The decision to continue is up to you. You guys are it's not going to happen. Yeah, are you guys ready?
Yeah.
Back on the record?
Yep.
After conferring with the candidate, I'm a little sorry that I had to waste your time discussing my objection and petition objection, but he'll be unable to obtain those affidavits, so we're prepared for the ruling on the matter. However, it is also our duty to notify you of, unless there is a corresponding prohibition against it through city ordinance, we are going to stage a write-in campaign, and the essential documents will be tendered to the city clerk. I believe it's form SBF P1E, whatever their numbering system is. But it's our duty also to notify you, and then we'll also make the formal submittal. So yeah, sorry to have.
Oh, that's okay.
Okay.
That's.
All right, so.
Council's embarrassed.
Okay.
Oh, no worries.
It's
No
calls
worries.
out too.
It's all right, to being honest.
Okay. So, and I guess I would put this question to you, and it's certainly up to you. Would you prefer that this board rule on the objections, or are you withdrawing the candidacy? They're two different things.
You could rule on the
Okay.
objections. That'd be sufficient. Thank you.
Okay. So based on that, I mean, unless the objector, you don't have any objection to that, correct?
You're ruling on the candidacy today?
Yeah. No. Yes.
Rule on those 17 days?
Right. He's saying that we're ready to go, so no objection.
I have no objection to you moving forward. I haven't heard any evidence that has been presented today to refute the 17 that were sustained, so I'm happy to have you rule today.
Okay. Well, I mean, as I stated at the beginning, this is the number of signatures is a mandatory provision. If without evidence to counter or challenge the county's rulings, typically you take what the county did and presented and spent some time on as evidence that the records examination is sufficient on the 17 signatures, that they are invalid. It's still up to you to decide one way or another whether or not, in this case it would be to sustain the objection, which would be to rule in favor of the objector and say that the nominating petitions are invalid because they don't meet the minimum signature requirements, or to overrule it without the evidence.
Going against.
Right, that really what we have is the county's record exam as the one piece of evidence submitted.
So any other questions or comments? Okay, seeing none, I'll start. Then I would support sustaining the objection given the evidence presented or the results of the records checked by Cook County, and lacking any evidence here today or anything going forward. I would move to sustain the objection.
And for those many of those same reasons, I would vote to sustain the objection as well.
And I'm inclined to do exactly that, to support the sustaining of the objections, because I consider the word of the county very invalid. I mean, valid.
I prefer your first sentence.
I know you like that better. Slip of the tongue. I'm sorry it doesn't help your situation, but I hope we've learned by this situation. I hope your candidate has learned also that he needs to read more of the direction and get a better listing next time.
Okay.
Sorry.
So that is 3-0 to sustain the objection, which means that the candidate's name will not be written on the ballot. I had prepared, in the election code requires that this board adopt a written decision in open session to avoid delaying and having to continue it. I have a draft decision, but I didn't have obviously any of the rulings written in there. If we could take maybe 5 or 10 minutes, I can go back in the office and put in what you guys actually voted on.
Then we can adopt.
And then you can adopt it on the record. We'll still be done by 9, which I think was everyone's hope. So if there's no objection, I would say recess for 5 or 10 minutes.
Okay.
And I'll type really fast.
All right, so we'll do that, and we'll be back here in 5 or 10 minutes to adopt that.
Saying I declare myself as a writing candidate. They can also probably get that from the Chicago Cook County office as well.
Okay.
All right, we are back from recess with the written decision?
Yeah, back on the record. Most of the decision had been written in advance because we were able to put in the summary of the objections. So the history of the first hearing, the exhibits that had been approved and adopted, and we will be sending the full decision with exhibits as well, but we do have to adopt the actual decision today. The piece that was missing that I just added in would be on the rulings in paragraph, paragraph 17 and paragraph 19 throughout there about how the electoral board ruled on both the notarial block as well as the signatures. And then I think the most important piece would be under the order on page 3 that the objection is denied in part with respect to the validity of the statement of candidacy. That's the notary issue. Granted in part as to the challenge to the sufficiency of the number of signatures. Both were by a vote of 3-0, but now the board needs to formally act on this decision, and then it will be signed. So if we call for a motion.
I will entertain a motion to approve this decision.
So moved.
Second. I second that.
Thank you.
All right.
Any discussion or questions? Do I go out to the audience?
You can.
Any questions or comments from the audience? Okay, seeing none, back to the board. Can I do a voice vote?
You can do voice. Mm-hmm.
Okay. All those in favor signify by saying aye.
Aye.
Those opposed? Motion carries 3-0.
Okay. Thank you, everybody.
Then I'll entertain a motion to adjourn.
So moved.
Second.
Thank you. All those in favor signify by saying aye.
Aye.